Well, thank you, Bronwyn and Jackson and Lou, for having me tonight. I'm very excited to come and speak with you this evening. Um, as Jackson mentioned, I'm the Deputy Commissioner at the Environmental Commission of Ontario. And I'm going to be talking to you tonight, first off, on who we are and what we do, because many of you may not know about the Environmental Commissioner and its very important role. And then moving on to the Environmental Bill of Rights, which is some rights that relate to you and I think are very important for all Ontarians. After that, I'll be discussing Ontario's risk-based approach to protecting species at risk, and then trying to link the two, showing some examples of how public participation under the Environmental Bill of Rights has played a role in improving species at risk protection in the province. So first off, the Environmental Commission of Ontario. In Ontario, we have 9 legislative officers. So these are officers that are sort of mandated by the government under different legislation to play an oversight role of the government. And these include officers like the Auditor General of Ontario, the Ombudsman of Ontario, the Financial Accountability Officer, the Information and Privacy Commissioner, and the Environmental Commissioner of Ontario. So our mandate is specific to the environment. And in particular, we are the guardians, promoters, and champions of Ontarians' Environmental Bill of Rights, which I'll get into in a moment. We are a watchdog on environmental protection, on energy conservation, and on greenhouse gas emissions. And this is the current Environmental Commissioner, Dr. Diane Sachs. She was appointed in 2015 for a 5-year term. And like the other officers, we don't have the power to make the government necessarily do anything, but we are required to report to the legislature and highlight issues and make recommendations, trying to raise awareness of different issues and try to further and push the government to move forward on improving the environment. And so while we can't force the government to do anything, the commissioner often points to say that, well, we do have a can opener and a flashlight and a megaphone. So we have a can opener to open cans of worms, to try to find what are the issues. Do we have access to information where we can try to compile data and information to figure out what are the problems? We use a flashlight to try to peer into problems more deeply than other organizations might be able to. And we have a megaphone or a soapbox to stand up and report to the legislature on things that we think that Ontarians and the legislature and the media should know about. So we are required by our legislation to report to the legislature 3 times a year. So we have 3 annual reports. Our primary report, which we now call the Environmental Protection Report, we've been releasing since 1994. It was our annual report for many, many years, and it focuses on reporting on how the government is doing in complying with the Environmental Bill of Rights. It also covers a wide variety of environmental issues like air quality, water quality, waste diversion, wildlife management, and other things that don't fit into our other reports. Our second annual report is reporting on progress in Ontario on reducing greenhouse gas emissions in the province, so fighting climate change. And we released our most recent climate change report in September. And the third one has to do with energy, so focusing on how is the province doing in improving energy conservation and reducing energy use in the province. And then besides these 3 annual reports, we're authorized with releasing special reports on any subject related to the environment that we feel can't wait for an annual report. So we've released reports on species at risk, waste diversion, and many other different things. And all of these reports are available on our website. So this is a wealth of information here that you can go and find all of these reports. So moving on to the Environmental Bill of Rights, it's a law that was passed in 1993 and came into effect in 1994. And it's based on the premise that Ontario's environment belongs to Ontarians. And so Ontarians should have a say in the decisions that the government makes that affects the environment. And it's also based on the idea that the government doesn't know everything, and that Ontarians have good ideas and should be able to participate in the decision making so that they can inform the government's decisions. It's also based on the premise that no one ministry within the government is solely responsible for environmental decision making. So not just the Ministry of the Environment, Conservation and Parks, but other ministries make big decisions that can affect the environment. So the Environmental Bill of Rights was passed under the principles of transparency, accountability, and public participation. And so in the past, before the Environmental Bill of Rights, the government could pass decisions or make decisions behind closed doors without public input and without letting the public know what they're doing. The Environmental Bill of Rights, or the EBR, increases public participation in government decision making, and it also gives Ontarians more access to tribunals and courts. And there's several ministries, 17 right now, that are caught under the Environmental Bill of Rights, or EBR umbrella. And the most important in terms of environmental decision making are certainly the Ministry of the Environment, Conservation and Parks, and the Ministry of Natural Resources and Forestry. But many other ministries, including agriculture, food, agriculture, and rural affairs, the Ministry of Energy, Northern Development and Mines, the Ministry of Municipal Affairs and Housing, and the Ministry of Transportation certainly are caught under this legislation and have responsibilities. Now, the primary way that Ontarians can participate and be involved in government decision making is the Environmental Registry. So this is an online platform, a website, where you can go and see proposals that the government has posted on things it's planning to do that may have an impact on the environment. And this website is maintained by the Ministry of the Environment, Conservation and Parks, but all of the ministries that have responsibilities under this act must post their proposals on this platform, and gives you the opportunity to see what's going on. So the ministries that are caught have to post policies, acts, regulations, and instruments, which include permits, approvals, licenses, and other things that could have an impact on the environment. So this includes permits to take water. If, say, Nestle wants to take a bunch of water from outside Guelph, then the Ministry of the Environment, Conservation and Parks would post a proposal notice on the registry asking Ontarians to comment on this proposal. Other things that are caught and posted on the registry include strategies and plans, like when the government is making new strategies that have to do with climate change and greenhouse gas emissions, renewable energy approvals, when they're passing new laws or acts or regulations involving drinking water. All these sorts of things are caught and posted on the registry for public consultation. Here's an example. Recently, the government canceled cap and trade in Ontario and didn't immediately post on the environmental registry the fact that they were proposing to do this. And our office was involved in pushing the government to say, you actually have to consult the public on this. And so shortly thereafter posted this proposal notice on the registry asking Ontarians to comment on their feelings or their thoughts on canceling cap and trade. And since then it has received thousands of comments that our office will have access to go through and comment on. So once a ministry posts on the registry a proposal of what they plan to do, it gives Ontarians the opportunity to see what's going on, so there's transparency there, and the opportunity to comment. And so the bare minimum under the Act is 30 days. Sometimes if it's a complex piece of legislation or a really big overhaul of an important act, then the ministries will provide 45 to 60 days of consultation. But the bare minimum is 30 days. Once the comment period closes, the ministry reviews all the comments that it receives and is supposed to use that information before making its decision. And when it posts a decision on the registry, provide a summary of how it took those comments from the public and how those comments helped inform its decision. So the value of this website and the environmental registry is it shows us as Ontarians what ministries are working on and what they're proposing. It lets Ontarians comment before the decisions are made. It lets you see the comments, unless you don't want your comment posted. All the comments that Ontarians submit through the registry are posted for others to see. And it shows you how the ministries considered your comments while it was making its decision. So even though the Ministry of the Environment, Conservation and Parks is the one responsible for this platform, our office realizes that not everyone is interested in everything that's posted on the registry. Maybe you're only interested in one particular species at risk or a particular part of a geographic area of Ontario. So we created a system or a program that you can input keywords that you're interested in, and it'll scan the registry daily and send you an email to alert you to the fact that there's a registry notice that may be of interest to you. and then you may want to go and comment on that notice. So if you go to our website, you can see and sign up here for to get registry notices to your email that might be of interest to you. As an example of things that are posted that might be of interest to people in and around Hamilton, for example, just November 1st, the Ministry of the Environment, Conservation and Parks posted this proposal notice for a company called Canadian Liquid Processors Limited, which you can see is located over here on Bigger Avenue in Hamilton. And this facility processes and transfers non-hazardous solid waste as well as some liquid waste. And the ministry posted a proposal notice saying that they're proposing to amend this facility's environmental compliance approval to revise its site plan and the structure of its outdoor facilities. So they're asking the public if anyone has any information that is useful in informing this decision or has any thoughts on what they're proposing to do. You have until December 16th to submit a comment. In addition to being able to comment on proposals that the government posts, the Environmental Bill of Rights also gives Ontarians the ability to ask the government to do things. So if you think that a particular piece of legislation or a policy act or regulation or an approval, like a license or a permit or an approval, needs improving to protect the environment, you can ask for a review. It's called an application for review. And you submit it, forward it to our office, and we go through it before forwarding it on to the relevant ministry. So people have used this tool before to ask the government to review the Mining Act, as well as a wide variety of instruments, including specific permits to take water. You can also use this tool if you have a great idea and say, look, there's an environmental gap in this province, that you're overlooking something that's really important. And I think that you should have a new policy act or regulation to protect X. Then you could submit an application for review to do that. And people have done that in the past to ask for increased protection for the Waterloo Moraine. So as an example of how this has worked in practice, this is Rick Holt. He was part of an organization called Gravel Watch Ontario, which is a not-for-profit pushing for improved aggregate extraction in the province. And he and his fellow co-applicant felt that the way that aggregate pits in Ontario were being rehabilitated was inadequate. So he submitted an application for review under the Environmental Bill of Rights, asking the government to review the Aggregate Resources Act to try to improve it. And the Ministry of Natural Resources agreed, conducted a review, and in the end took action and amended the act to improve certain things about the act, including the reporting requirements for aggregate operators, the powers for ministry inspectors, and expanded the scope of the act and increased the amount of money that each of the aggregate companies had to pay in to help improve rehabilitation of its pits in the province. In another example, two University of Toronto students used this tool. They noticed that certain condo bylaws and housing developments were putting restrictions on people that prohibited people from using clotheslines in their backyards to dry their clothes. And they argued that, well, this isn't right. I mean, it's a low-cost way for people to save energy instead of using your dryer. We should be encouraging people to hang up their clothes on clotheslines. So they submitted an application for review, asking the Ministry of Energy to just make one little change to an act to insert the word clotheslines and make these sorts of restrictions illegal. And the ministry agreed, and as a result, they were successful in their request. The other type of tool is if you have evidence or reason to believe that someone is breaking an environmental law, then you can submit an application asking the ministry that's most appropriate to investigate. So if you have reason to believe that, say, for example, a company is breaking its environmental approval or breaking the Environmental Protection Act or dumping pollution in water without a permit, then you can ask for an investigation. Likewise, if you have evidence that a company is damaging habitat to a species at risk without a permit or a registration, you could request an investigation. As an example of this, several years ago, two people had evidence that several provincial parks were contaminating the environment from their outhouses and their washroom facilities. Basically, the sewage lagoons and the outhouses and washrooms were dumping raw sewage into the environment. And so they had evidence of this and submitted it to the Ministry of the Environment, asking them to review and investigate Ontario Parks, which manages our provincial parks. And the ministry did an investigation, went to those parks and did find non-compliance. And as a result, they had a provincial officer come out and follow up and ensure that those parks eventually were brought into compliance, and encouraged all of the parks across the province to improve their sewage management practices. And a local example, this is Environment Hamilton, which is a local environmental organization. Linda Lukasik and Don McLean, working at Environment Hamilton, noticed that an industry over here, McAsphalt Industries, seemed to be operating without an approval. They noticed that they were in production and operating, but yet didn't have an approval that had been posted on the environmental registry. So they submitted an application for investigation, asking the Ministry of the Environment to investigate. And sure enough, the ministry did, and found that the company was operating without an approval, and ordered the company to cease its operations until an approval was issued, and ensured that the approval contained terms and conditions like installing equipment to control its emissions, and ensured that there was a commitment to monitor and inspect the facility. So over the years, applications for review and applications for investigation have been submitted by a wide variety of Ontarians, some of which are just regular Ontarians or students, as I mentioned. Some are environmental organizations, First Nations, and in some cases, councillors, MPPs, and mayors have submitted these applications. And over 650 applications for review and I think 230 applications for investigation have been submitted over the years. And even when a ministry denies the request to conduct a review or an investigation, it still can encourage the ministry to highlight the fact, or even if they don't immediately conduct an investigation, it's on the ministry's radar to do something. And the important part of this entire process is the ministries are required to respond to you within specific deadlines in writing that comes to our office as well. So unlike writing a letter to an MPP or a minister, which may not necessarily get a response, this requires a response from the ministry. And our office plays a role in overseeing how the ministries comply with the Act and handle these applications. The other type of tool under the Environmental Bill of Rights is an appeal right. So when a ministry makes a decision on an approval and posts on the registry a decision on a license or a permit or an approval, if you as an Ontarian disagree with that decision and have a vested interest, you can appeal that decision within 15 days. And the first step, because it's a bit of a hurdle, is to seek permission from the appropriate body to appeal that decision. And that typically would go to the Environmental Review Tribunal. And even though this is a bit of a hurdle, about 20% of those that go through this process do get their opportunity to present their arguments to the tribunal. And an example of this is a few years ago, the Ministry of the Environment approved a permit to take water for a hydro dam on the Rocky Saugeen River, and an applicant requested an appeal, and it went to the Environmental Review Tribunal, and basically they were arguing that the river was at risk from this dam, and that further studies were needed to assess the impact of this dam, particularly because the water temperature of the river was changing because of the dam and affecting fish downstream. And they also argued that the period of the term of the permit to take water of 10 years was far too long. And even though this didn't go to court, I mean, the Environmental Review Tribunal said, yes, you do have grounds to appeal this decision. In the end, the proponent of the dam sat down with the person who was appealing the decision, and they were able to mediate and come to some settlement on changes to the approval in the end. And as a result, they changed that permit to take water from 10 years to 5 years. They added some new clauses about the dam's operation. They added some record-keeping requirements, and they had a requirement that the run-of-the-river flow be restored immediately after power interruptions. You hear this scorecard. One of these categories is unposted. So reporting how often or what percentage of a ministry's decisions that it makes aren't being caught by the environmental registry. So that wasn't just a one-off. Like this has happened for years, and certainly over the past 2 years under our new commissioner, us doing these scorecards and pushing each ministry to improve their compliance has improved their standing in posting these things on the registry. So moving on, I thought something that might be of interest to your group would be the way that the province manages its species at risk. And we reported on this in our environmental protection report last year, and I brought some of our summaries here for you to take with you. As you likely know, the world and Ontario is in a biodiversity crisis. Not only are animal populations falling at an alarming rate, but we're losing species going extinct um, at a devastating rate. And so Ontario has 200 listed species at risk under the Endangered Species Act. And this graph is showing the sort of the stages from being a species of special concern through to threatened, endangered, and then extirpated, which is a species that used to live in Ontario and may live somewhere else, but no longer lives in the province. So it's trying to reduce the species that get listed on here, which is, not only reducing the species that get listed and making sure that they recover their populations, but also not trying to prevent them from getting upgraded on this list to go from species of special concern through to extinct or extirpated. And so species can become endangered or imperiled for a wide variety of reasons. Can be based on their biological characteristics, their life history, if they're a long-lived species with a slow maturation or sexual maturity, then that can have an impact on their population size. And that there can be local and global reasons that can affect the species. But in particular, habitat loss is a major one for species at risk, as well as invasive species, climate change, and pollution. And also harvesting or overexploitation. So hunting, trapping, or collecting can have an impact. And that's something to bear in mind because hunting and trapping is largely within the control of the ministry, unlike or the government, unlike climate change and pollution and invasive species are a lot more difficult to tackle. So the Endangered Species Act is Ontario's framework for protecting and recovering Ontario's species at risk. And it does this by making it illegal to kill, harm, harass species at risk, but also to damage or destroy their habitat. And certainly the problem is things are not necessarily getting any better. And what this graph is trying to show in red is that each year, this is the number of species that are added to the species at risk list or upgraded and going to a higher threat category in red versus green, which is species that are removed from the species at risk list or downlisted. So each year you can see the red is outweighing the green. And so more and more species are being added to our species at risk list, which means more and more species are being put at risk and threat. So in 2008, when the Ministry of the Natural Resources revamped its endangered species legislation, our office released a special report called The Last Line of Defense, where we raised some major concerns. And we said, well, the legislation actually is quite a good framework at helping protect species at risk, but it'll all depend on how the ministry implements it. And in particular, the legislation gives the ministry the ability to give a permit to companies and proponents that want to harm species at risk. So it allows them to cause damage to species, but the permit, most of the permits that were being issued were called overall benefit permits. So what this meant was if this was the current state of a species at risk and doing something, let's say installing a water-powered dam, would have an impact on the status of that species, you would have to do more than just mitigate the impacts and minimize harm, but you would actually have to do something to try to leave the species in a better state than which it was initially found. So if you were destroying, say, a bunch of protected trees, or say the butternut tree, you would have to plant a bunch of trees somewhere else to show that you're demonstrating an overall benefit to the species at risk. So our office flagged, okay, this is a good idea in principle, but it all depends on how many permits that the ministry issues and the sort of conditions that the ministry puts into these permits. And then in 2013, the Ministry of Natural Resources and Forestry decided to try to streamline its system and say, we want to focus more on high-risk activities. So rather than these low-risk things like forestry and aggregate operations and mineral exploration, we're going to focus on other things. And instead of having permits and agreements between the ministry and the proponents, all you have to do is register and follow the rules that are listed in the regulation. So this is a permit by rule system. So as long as you're following the rules, which are meant to mitigate or minimize the adverse impacts on the species, then you're in compliance with the Act. And this applies to many different activities like forestry, aggregates, water power, um, and infrastructure activities like road maintenance and road building. And so after 2013, you can see here, these are the permits and agreements that were for species at risk beforehand. And then after 2013, when this new permit by rule system came into place, where all you had to do was register, all these sorts of registrations came through. And so a lot more companies and proponents are using this system and signing on to do harm to species at risk after this new sort of permit by rule system came into place. So to our office, this kind of implied that there was a lot of activity that was happening before that wasn't being caught by this system. And now that we have a more sort of proponent-driven, streamlined process in place, that more and more registrations are happening that can harm species at risk. Now, one could argue that perhaps this is a good thing, that, okay, more and more companies are being brought on board to do things, to follow the rules and protect species at risk. But when you come back to this sort of diagram, under this new system of permit by rule, you only have to minimize the adverse impacts. You don't have to have an overall benefit for the species. So all you have to do is try to mitigate the impacts on the species. So there's a lower level of protection for those species. The other problem with this system is the ministry didn't get or even give itself the authority to inspect how well people are complying with the rules under the regulations. So if a company registers to conduct something under the permit by rule system, the ministry doesn't even have the authority to go and check whether or not they're complying. So our office flagged that with the ministry, and they recognized that that was a big problem, and they knew right from the beginning that that would be an issue. And so we see that as a major glaring error in the ministry's ability to do its job. And the last thing is the ministry isn't checking to see whether or not this new system is actually doing anything to benefit species at risk. Is the system working at all to do what it's intended to do? Even worse, this system shuts out the public from participating. Even though the Ministry of Natural Resources and Forestry is a ministry that's prescribed under the Environmental Bill of Rights and required to post permits on the registry for public consults, there's many exceptions to these rules under the Act, and so these permits are not posted for public consultation. And those registrations under the permit by rule system are not caught, and there's no way of really knowing where and what is happening with these registrations. Unlike the Ministry of the Environment, which has a website called Access Environment, where you can go and see approvals like environmental compliance approvals that are dumping into water and air. You can see a map of where things are happening and look up specific proponents and license numbers. These sorts of things under the Ministry of Natural Resources are not being caught. And I mentioned that that appeal right, the ability to appeal a government decision, that doesn't apply to these sorts of permits and registrations. So the public is essentially shut out from knowing what's going on and being able to participate in those decisions. And an example that I'd like to highlight is the barn swallow. So it's a threatened species under the Endangered Species Act, and it's threatened by habitat loss, the changes in its insect prey, and by climate change. And before the ministry came out with its permit by rule system, there were only 2 permits that were issued to do harm to the barn swallow. And then after 2013, when this new proponent-driven approach came through, all of these registrations came into effect, and companies, 520 registrations have now been filed. And more than 50% of these registrations are under something called the non-imminent health and safety exemption, which doesn't even require a formal mitigation plan or species-specific mitigation sort of measures. So reviewing this, I mean, we released 2 special reports on the Endangered Species Act. And then last year, we, in our environmental protection report, reviewed this new permit by rule system and had major criticisms of it. And here I list several of the recommendations, one of which is determine and report on the impacts of this system and publicly report it. So let the public know whether or not it's actually working in improving or at least staying the harm that's happening to species at risk. And we also pointed out that your enforcement officers within the Ministry of Natural Resources should have the power to inspect how well proponents are complying with the permit by rule conditions. We recommended that the ministry post those instrument proposals on the environmental registry for all permits that people can comment and appeal them, and make all those risk authorizations available on a website like Access Environment so people can see what and where things are happening. And lastly, amend the Act to create a right of appeal for those permits so that people can appeal those decisions. So given that overview of the Endangered Species Act, I want to try to give some examples of the link between the Environmental Bill of Rights and species at risk. So a core principle of the Environmental Bill of Rights is the conservation of biodiversity. And the Ministry of Natural Resources and Forestry is a prescribed ministry. It has requirements under the Act to notify and consult the public, but there's a lot of exemptions, like I just mentioned. But the Act is caught in the sense that people can submit applications for review and applications for investigation to the ministry. And when we look to see in 2016 and 2017, what were the most highly commented proposals on the environmental registry, many of them relate to the Endangered Species Act. So you can see here, 13,000 comments were submitted on proposals for rules having to do with the hunting of snapping turtles. And then a few other ones had to do with the hunting and protection of Algonquin wolves and other wolves in the province. So I'm going to focus just for a minute on the snapping turtles. Reptiles are a huge part of the biodiversity crisis in the world and the province. I think 1 in 5 of the reptiles in the world faces extinction, and in the province, 7 of our 8 turtle species is on the species at risk list. And even though they only represent 9% of the endangered and threatened species in the province, when we looked at the number or the proportion of registrations under that permit by rule system that were being used to harm species at risk in the province, birds were particularly affected, but also reptiles. So they are particularly being affected by this permit by rule system. Now, snapping turtles are a very long-lived species. They can live up to 100 years, and they reach sexual maturity at about 17 to 19 years. So the loss of even just a few individuals from the population can have a major impact. And here are reported harvesting numbers for the snapping turtle from 2012 to 2016. And even though these numbers are not very high, they can have a major impact on this species because of their life history. So to give you an overview of what's happened with the history of the snapping turtle over the past few years, in December, 2 members of the public used that tool under the Environmental Bill of Rights to submit an application for review, asking the Ministry of Natural Resources to end the snapping turtle hunt. Even though this species is a species of special concern, and you're able to hunt it unlike threatened and endangered species, these members of the public submitted the application saying, well, we don't really have any clue how many snapping turtles are being taken, but we do know that the loss of even just a few can have a major impact. So you should ban the hunting of snapping turtles across the province. And in response, the ministry denied this request, saying that its conservative harvest regulations had already reduced the hunting pressure on the species. And in our annual report, our environmental protection report, we disagreed, and we recommended that the government ban snapping turtle hunting across the province. Next, the ministry said, okay, well, we're not going to ban hunting of snapping turtles, but we do think that perhaps we should have mandatory reporting. If you're going to take this species from if you're going to kill some snapping turtles, then you have to report it to the province. And so they posted a proposal notice on the environmental registry for public comment. And the overwhelming public outcry was, no, you need to do more than just have mandatory reporting. You need to ban the hunting of this species. So there were 400 public comments and a petition with more than 11,000 people asking the government to end the hunt. And in the end, the ministry decided to proceed and proceeded with allowing hunting to continue, but requiring people to report the numbers that they take. So we come back to this chart. Since 2012, hunters had to report how many turtles they killed in the province. And so in that first year, there were 4 harvesters. That 3 years after our report, we were a bit surprised, but eventually the ministry said, yes, you're right. Well, before we got to that stage, actually the ministry said, okay, we're not going to ban snapping turtle hunting, but we are going to shorten the season. And we're going to reduce the limit from, I think it was either unlimited or maybe 2 per day to 1 turtle per day. And the public outcry to that, to the proposal notice that the ministry posted, was over 13,000 comments, and people were up in arms about, no, you just need to finally close the hunt of the snapping turtle. And so eventually the ministry said, based on public feedback, there was significant opposition to maintaining any open season for snapping turtles. And so as a result, the ministry finally canceled the legal hunting of snapping turtles to maintain the population. So we were very happy at the success story. And you can see all the different parts of the Environmental Bill of Rights came to play, or several of them, including the use of the environmental registry to consult the public, the application for review process that prompted or tried to get the government to ban the hunting of snapping turtles, and the reporting of our office in multiple reports to push the government to ban the hunt. And one other example I'd like to leave you with is to do with the Algonquin wolf. So this is a genetically distinct species, and it's an ecologically important predator. Not only does it have direct impacts on its prey, like beaver and deer and moose, but it also can have indirect cascading effects on the whole ecosystem. So in hunting deer, it can reduce the browsing of the forest understory, and so as a result can improve and increase the growth of trees and forests, which can create habitat for other wildlife. And in hunting beavers, which are ecosystem engineers, they can have an impact on beavers' availability to dam, rivers, and streams and lakes, and so can have an effect on the habitat for aquatic species. And the role that these wolves play can't be filled by smaller canids, smaller members of the dog family like foxes and coyotes, because their size doesn't allow them to take down large moose and deer. So they play a very important ecological role in the province. So the Algonquin wolf, which is sometimes known as the eastern wolf, is found in central Ontario and in southern Quebec, and about 2/3 of that population are found in Ontario. And scientists estimate that there's somewhere between 250 and 1,000 mature individuals left, likely on the lower end of that scale. And because wolves tend to shy away from human disturbance, they tend to live in protected areas, in particular in and around Algonquin Park, which is where they get their name, but also some other protected areas where hunting and trapping is illegal. And that includes Kawartha Highlands, Killarney Provincial Park, and Queen Elizabeth II Wildlands Park. So in and around these 4 parks, we find these concentrations of the Algonquin wolf. And the problem is, wolves need more than just these little pockets of land. They need space to move and roam. They require vast landscapes to go hunting for their prey, but also to find mates and to form their own packs. Now, the central threat to the Algonquin wolf is hunting and trapping. And one of the problems is it's difficult to visually distinguish between coyotes and the Algonquin wolf and even the gray wolf. So a hunter, even if they're not trying to kill Algonquin wolf, might mistake it for a coyote. And scientists have found that Algonquin wolves are particularly vulnerable to hunting and trapping, more so than the other wolf and canid species. And that the juveniles leave their pack when they're about 9 months old. And when they leave their pack and they leave a protected area, then they're out in Ontario where they could be caught either through hunting and trapping. So the juveniles are particularly vulnerable to this threat. And when we look at the numbers, unfortunately, we don't really have a great picture of what's going on because the Ministry of Natural Resources doesn't require DNA sampling of the hunted and trapped species that are individuals that people capture. All we can get a picture of is the number of wolves or canids that are killed in and around the area that this particular species is found. So that's the orange bars here. And so this is the number of canid individuals that are harvested in northern Ontario in the area that we know that the Algonquin wolf lives. And this is the number of canids that are trapped in that same area. So again, turning to the Environmental Bill of Rights, 2 Ontarians used that application for review tool to ask the ministry to revise its legislation and its policy framework for managing wolves, and ask the ministry to classify this wolf as a unique species. Previously, it was assumed that it was a subspecies of other wolves, but they said, no, this is a genetically distinct species and should be treated as a species at risk. And so asked the ministry to do this, and asked the ministry to end the hunting and trapping of the eastern/Algonquin wolf, and to review its wolf conservation strategy, and and to end the harvest of wolves in all protected areas. And the ministry denied this request, and in our annual report, we disagreed with this decision, and we recommended that the ministry manage eastern wolves as a specially protected mammal, which means that you could not hunt or trap it. So then the ministry decided well, in the end, the Algonquin wolf was listed as a species at risk in Ontario. It was listed as a threatened species and a genetically unique one. And under the Endangered Species Act, it's illegal to hunt and trap threatened and endangered species. But the ministry decided to, rather than provide this blanket prohibition for Algonquin wolves, they decided to exempt it from this hunting prohibition, and instead proposed to the public that there be certain other protections for the species, and simply that within certain protected areas in and around Algonquin Park, Killarney Highlands, Kawarthas, and Queen Elizabeth II, that there be a ban on hunting and trapping in the parks and around them. But there was already a ban on hunting in those parks. So this particular proposal isn't very effective at reducing the harm to the species. And the ministry posted on the environmental registry asking the public to comment on this, and received over 17,000 comments from a wide variety of commenters, but the majority of which certainly opposed the proposal and saying, you should ban the hunting of the species in the extent that we know that where it occurs. But in the end, the ministry decided to go ahead with its final decision. So not such a great success story as the snapping turtle, but do want to point out that the Environmental Registry and the Environmental Bill of Rights have been involved in trying to push this along. But as a result, today, if we don't do something, or the ministry doesn't do something to improve the protection for this species, scientists don't think there's any chance of recovery. And these season closures in and around these provincial parks isn't enough to provide the vast landscape and habitat that's needed to protect these species. In particular, in the south of their range, there's year-round hunting seasons for this wolf, and there's no game seals required, so there's no limit on the number of wolves that you can take, and there's no mandatory reporting of kills, so there's no understanding of how many wolves are being killed. And again, hunters can't discriminate between the species, and even when a member of a pack is killed, not only are you affecting the number of wolves in the population, but you're affecting the pack dynamics. And in particular, if a wolf can't go out and find a mate of its own species, it'll likely hybridize by mating with a coyote, which can affect the population. So our office, in last year's report, we again recommended that the ministry ban hunting and trapping of wolves and coyotes within the extent of its occurrence. So basically, where we know that the species lives, that they should ban hunting and trapping. And the ministry has posted on the environmental registry a draft recovery strategy, and then right before the election, posted another one saying we're going to need more time. And so I believe that they're now saying that in fall 2019 will be when the final strategy will be posted. So the lessons that I'd like to point out here is that change is incremental. Things don't happen overnight. And particularly with the snapping turtles, it took several pushes from many organizations and our office and the public to change the way that the ministry manages snapping turtles. But also, things are happening, ever so slowly with the Algonquin wolf. Many years ago, wolves were treated like pests, and certainly the fact that the ministry now has a management strategy and is treating it as a species at risk is important, but we would like to see a further protection for the Algonquin wolf. And while the environmental registry is really important in allowing people to submit informative comments that can improve environmental decisions, it also seems clear that public sentiment can play a role in what ministries do. And so the things that I just covered here, the snapping turtle, the Algonquin wolf, and species at risk are all covered in last year's environmental protection report, and I have the executive summaries at the back there if you'd like to see it. In addition to those issues, we covered algae in the Great Lakes, environmental justice for Indigenous communities who are disproportionately affected by pollution. We also covered protected areas, planning, and a few other environmental issues, as well as our scorecards for compliance with the Environmental Bill of Rights. So that's just that one report, but we have dozens and dozens of others that cover other topics and issues. And I promised just a very short teaser for the report that we're releasing to the legislature tomorrow. And the commissioner is saying we're releasing this report, and it's brought to you by the letter W, because we're covering water, wildlife, wetlands, and woodlands. So we're going to be covering pollution to water, in particular to sources of drinking water, and what that means for the safety of our drinking water. We're also covering wildlife monitoring and wildlife diseases, and the loss of wetlands and woodlands in southern Ontario. And again, our Environmental Bill of Rights scorecards. And so you were asking about how we reach out to people. Here's our website is eco.on.ca, but here's our email address and our main Twitter feed and our Facebook page. So, and we also have, I mean, if you go to our website, you can also find we have a 1-800 number. You can call our office, and even if it's not something that relates to our office, we're very helpful at trying to get people what they need to find the right person to talk to and help you with your issue. So thank you very much for having me tonight, and happy to take any other questions. Yeah. That's a good question. I think it was simply recreational. I mean, I don't think that people were eating them. No, I don't think so. You had that part on swallows there. I'm not absolutely sure, but I think like the swallows in Ontario. I've actually not named North America. They're swallows from Europe, but they become kind of naturalized. When you take your species, this is the rat. Is there any difference between native and non-native species? I don't think under the act, no. But I'd have to check on that to see. Yep.
In terms of snapping turtle mortality, how significant, do you have an idea of how significant hunting is relative to automobile trucks?
Well, certainly before, yeah. I mean, it's hard to tell because before the numbers weren't reported, and even when they were reported, certainly didn't seem to be covering all of likely the number of hunters who were taking. But now that hunting is illegal, habitat damage and road mortality is certainly the number one cause of death.
I'm curious about the forces that exist in the ministry that are seeming to always push against the saving of the snapping turtle or the wolves. Who is on the other side? What interests are being represented there?
So I'll just repeat the question. Sorry, I was forgetting to repeat the other ones. But she's asking what are the interests within the ministry, and how they're responding to requests to improve species at risk protection. That's a very good question. I can't answer that, what the motivation is, but certainly on many issues you can see where ministry's own scientists have pointed out issues with things, and the political will have made other decisions. So where our office comes at it strictly from an environmental standpoint, ministries have to balance a wide variety of factors, not only the environment, but also social and economic and political factors. In many cases, particularly with the Algonquin wolf, it could be lobbying from hunting organizations that see any restriction on the ability to hunt even coyotes an infringement on their ability to enjoy the outdoors. So I can't speak to how ministries make their decisions, only the comments that they receive.
Yeah, just to build on that a little bit. So, as an example, those 17,000 comments we registry, presumably the vast majority are supporting the environmental preservation position. So far, similar to that question, are there other avenues or sources or websites that are arguing that other side that you're aware of?
You mean like posting opposition to the ministries, what they're proposing?
Right.
In an anti-environment way?
Right.
I would say yes. Lobby groups certainly have websites where They will even post what they're planning on commenting on a proposal and encourage their members to follow and say, here's what you should, here's what we suggest that you put in your comment. Certainly there's, and I won't name them, but there are lobby groups that oppose environmental improvements. Yeah.
Is there any interest in encouraging a change in language to heighten blind spots? For example, I've seen the language of harvest, when I think kill, maybe calling it what it is would do a service in terms of raising it a little bit higher.
So the question was about the terminology and language used behind things rather than hide behind euphemisms. I think you're exactly right, but ministries probably use those terms very carefully, and it's not just within the environmental sphere that the terms that are used are very carefully thought out. Yeah.
How conscious are you or the urban versus rural perspective on issues in your work? My sense is politically that some of the political parties are acutely aware of that.
So the question is about sort of the geographic coverage or sort of the rural, urban divide in our work. We are very conscious of that. We're, our office and especially under our commissioner are very conscious of the fact that we are the Environmental Commissioner of Ontario and not just Southern Ontario. And so reporting on all sorts of issues, and if you look through our past reports, being very cognizant of focusing on the far north and Southern Ontario at the same time, and reporting on issues that affect Northern Ontario and rural Ontario as well, and making a very conscious effort for the Commissioner to travel around the province. So she has an extremely packed travel and speaking agenda, and she makes a big effort to go around the province, particularly to rural and Northern Ontario, to make sure that she hears from all Ontarians, and it's not just a Southern Ontario focus. It's a Southern Ontario urban focus.
That one.
Yeah.
As an environmentalist or a conservationist yourself, is there anything that you're worried about in this region particularly? Things that when you step away from your job, you look at what's happening. Is there anything that you that are red flags in your mind? Or
well, I think as I pointed out on the map, I think the big one is in Southern Ontario. We have a lot of species at risk here. We have a lot of development. It's a very small area, and it's important that we make sure that we continue to set aside land and think about making sure that we put in place the measures that are required to minimize those impacts. So we recognize there's a lot of people in the Greater Golden Horseshoe and in Southern Ontario, and we need to build infrastructure. We need to build roads. We need to build transportation and electricity corridors. But it's making sure that we be very cognizant of taking those measures that are needed to minimize those impacts on the environment. Mm-hmm.
The question, in sort of reversing things, if you find that you don't have enough data in order to neutrally comment upon an issue, for instance, the staffing service, do we know how many are in Ontario that are over 10 years old? Is anyone counting them? Have you thought of a way of mechanism? You're looking at the public through your website to have alerts put out. Hey, come and look at this. Somebody is in violation of regulations. Do you have a mechanism to request assistance from organizations like ourselves? You saw bird count information that we're going to be doing.
Yeah.
Other organizations of like mind or universities who have naturally students who do studies. Do you have that in place?
Right. So the question is about how our office gets information and data, especially when there seems to be a lack or an information gap. And we do build relationships with all sorts of organizations, particularly university researchers. And when we're looking at a particular policy or environmental issue, we'll determine, okay, who are the people who do have access to that information. And we'll try to get what we can through the ministries, but then there's other stakeholders and researchers and citizen scientists who we can turn to get a better sort of more fulsome story of what's happening. And you can see in our reports times where the ministries will report one thing and we're able to rely on work done by some other outside organization, particularly a university, that contradicts or at least refutes that. Yeah.
Specific strategy beyond the website and social media, reaching out to young people, the next generation, secrets.
So the question is about reaching out to younger people in particular, and we do have an outreach strategy where we do go out to schools. It's a matter of determining where is the best use of our office's time. We're a very small office of 29 people. The vast majority are the people that do the policy analysis. So we have a small communications and outreach team, and certainly young people, young students. We do target in particular university students. I gave a talk last week at the University of Toronto to a conservation policy class on the same issue. Those students that are really interested and engaged in the topic and are going to become environmental lawyers and working in communities and are passionate about this are particularly excellent promoters and good people to target in terms of outreach. We do go into schools and quite often we'll have student classroom workshops, but there the students are not so much interested in their environmental rights. It's more sort of climate change and sort of helping species in general. So it's more sort of environmental literacy and awareness and enjoying nature, which is important, but not like our role is to promote the Environmental Bill of Rights and not necessarily do the ministry's job or others' responsibility of encouraging Ontarians or young people to be environmentally aware. Mm-hmm.
Yeah, I'm wondering, since there's a climate change crisis, how can the environmental rights use pressure on
Well, the best way to use so the question was how can one use the Environmental Bill of Rights to apply pressure, as with all issues, not just climate change. It's using those fundamental tools of commenting when the ministry does post things, and they will be posting sometime soon, apparently, an environment or a climate change plan, and so we'll be posting that for public comment, or even submitting an application for review. There was recently an application for review that was pushing the government to basically calling into question the government's decision to cancel cap and trade. So you can use those tools to request what it is that you're wanting. Yeah. So very good question about how does the ministry take the comments and use them to inform their decision making. In multiple conversations with ministry staff, they've stressed that the registry is not a vote, it's not a petition, even though we do see 13,000 people commenting and perhaps the vast majority are against snapping turtle hunting. The way that they've characterized it is it's meant to inform the decision, and so that it's the information. So if someone submits a comment and says, I understand you're wanting to change the boundaries of this protected area, and you're forgetting that there's an important wetland right here, or there's a species that you're neglecting. Here's some information that I think that is important for you to improve your decision. They lump that sort of information together. And so where someone simply says, I'm against it, I'm against bear hunting, they kind of lump those together as these 400 people had the same sentiment, the same comment. And so we are informing our decision by the content of the comment rather than the number of commenters. But as I said in that one of my last slides, certainly the number can't go unnoticed by ministries. But I'd also mentioned that you can comment not only through the portal of the website, but you can also submit a letter on letterhead, and many organizations do. So the Ontario Bar Association and EcoJustice and other environmental organizations, or even planners and municipalities will submit on letterhead their comment and even like within town council meeting minutes say, okay, this is what we're planning on submitting to the registry. This is our town's or our organization's official comment on this proposal. And those can have a lot of weight. Certainly the ones that come out through the general public are taken and have to be considered. But the ones that come in on organizational letterhead definitely have a lot of weight, because it's the city of Vaughan and PO region are all against something, and formally posting it on their website and showing the province what it is that they're thinking, then the ministries notice that.
Take a couple last questions.
With the change of government, can you foresee your particular department having less of a clout than you did maybe under the Liberal government?
So I can't really comment on changes in government or this particular government. I mean, we're an independent officer. We report to the legislature. We don't report to the government, and we just to make that clear, we don't report to the government of the day. We don't report to the parties. We report to the legislature and all the members in it. And I don't know that we would have any less clout, but I think in all governments we have a role to play. What in the previous government and this one, there's always opportunities for improvement. Yep.
You mentioned specifically and frequently the Ministry of Natural Resources and Forestry, of course, the Ministry of the Environment, but another ministry that, as I understand it, has a great deal of potential control on or authority to, or the Environment, the Ministry of Agriculture, and under there, I guess, the Pesticides Control Act. I think that's a Ministry of the Environment document, isn't it?
Yeah. Yeah.
But the Ministry of Agriculture and Food certainly has a mandated interest, I won't say vested, mandated interest in how farmers treat the land. Thinking of imidacloprid as a pesticide, for example.
Mm-hmm.
Do you get many public reactions to the use of pesticides, imidacloprid, that whole realm?
I mean, not now. A few years ago, certainly, when neonicotinoids first came to we reported on it, I think about 3 or 4 years ago, as this is a growing concern, and then the Ministry of the Environment did act on it, and certainly I think the feds are also acting on it. So we don't see so much of the raised concerns from the public now on that.
Well, on behalf of everyone here tonight at the Hamilton Naturalist Club, we'd like to thank you so much for coming down here tonight, sharing all of this with us. Let's put our hands together for Tyler.